Welcome to the deep dive. Today we're getting into a concept that really ties lawyers and law students in knots, proximate cause. Specifically, when does a totally separate negligent act by someone else just, snap the chain of responsibility for the first person? And to do that, we have this incredible case, Derdiarian v. Felix contracting. The facts are just, well, they're intense. You've got a construction site barely protected by a single wooden barricade. Then a driver who skipped his seizure medication, has an epileptic fit, blows through that barrier and hits a worker. And it gets worse. He slams the worker into a giant kettle of 400-degree boiling enamel. So the question isn't whether the contractor was careless. They clearly were. The real fight was, does the driver's really dramatic medical negligence, does that let the contractor off the hook legally?
That's the whole ball game right there. And for you listening, our goal today is to give you a really clear step-by-step way to solve this exact kind of problem. We'll start with the basic rules, the policy behind limiting liability. Then we'll get really precise about the difference between a regular intervening act and a superseding one that breaks the chain. And then we'll apply it all, element by element, to the Derdiarian case.
Okay, so let's start big picture then. Why does the law even have this concept of, proximate cause? If the contractor's negligence was a cause, why isn't that the end of it?
Right. Well, it's because of policy. We can't have liability stretching out to infinity, like the butterfly effect. The law calls it legal cause, and it's all about putting some kind of manageable, sensible limit on responsibility. The first thing a plaintiff has to show is just that the defendant's negligence was a substantial cause of what happened. That's the baseline.
And who decides that?
The jury, the finder of fact. Because the key idea behind all of this is foreseeability. What should a reasonable person have seen coming? And that's almost always a question of fact, not something a judge usually decides on their own.
Got it. So the jury decides what's foreseeable, but then a third person comes along and does something else negligent. That's where it gets complicated.
Exactly. That's what we call an intervening act. But the key question is whether that act is so powerful, so out of left field, that it becomes a superseding cause.
And a superseding cause is what breaks the chain.
It severs the connection completely. It relieves the first negligent person of liability.
So what's the rule? How do we know if it's just intervening or if it's truly superseding?
The black-letter rule is this. Liability turns on whether the intervening act is a normal or foreseeable consequence of the situation the defendant created. In other words, was this second negligent act the very sort of thing you should have been guarding against in the first place?
Okay, so what are the specific elements? What makes an act superseding?
There are two key elements a court looks for, and if the intervening act meets just one of them, it's superseding. Element one, the act is extraordinary under the circumstances. It's just not foreseeable in the normal course of events. Or element two, the act is independent of or, far removed from the defendant's original negligence.
Extraordinary or independent. Got it. Okay, let's apply that framework. Let's analyze Derdiarian v. Felix contracting court. First, what are the legally dispositive facts?
All right, so Felix Contracting is on a job, installing a gas main. The key safety failure is that they only put up a single, flimsy, wooden horse barricade. That's it. The driver, Dickens, knows he has epilepsy and he's supposed to take medication. He doesn't. He has a seizure, loses control of his car, and drives right through that single barricade. He hits the plaintiff, Harold Derdiarian, and throws him into a kettle of 400-degree liquid enamel. Horrific burns.
And there was evidence they should have done more.
Oh, yeah. The plaintiff's expert came in and said, look, standard practice is to block the whole site off with a truck or a pile of dirt, something that can actually stop a car.
Okay. And what was the core legal issue?
The issue was whether the driver's negligence, specifically the seizure, was so unforeseeable and bizarre that it should be considered a superseding cause as a matter of law, which would break the causal link to Felix's negligence.
So what rule of law did the court use to decide this? Can you break it down into its testable elements for us?
Sure. The court used a really sharp, specific rule for these situations. It goes like this. An intervening act cannot be a superseding cause where the risk of that intervening act is the very same risk which makes the actor's conduct negligent in the first place.
So if you're negligent for failing to guard against X, you can't be excused when X happens.
Exactly. So the two elements we're testing, again, are whether the act was one, extraordinary and unforeseeable, and two, independent of the original negligence. If it's either of those, it's superseding.
Thank you. Now for the court's elemental analysis. Let's go step by step. How did the court apply that first element, the foreseeability or extraordinary nature of what happened?
Okay, so Felix argued that a seizure is, a freak event, an extraordinary thing. But the court said, no, that's the wrong way to look at it. The reason Felix had a duty to put up a strong barrier was precisely because of the risk that a driver would negligently enter the work site. And here's the crucial part. The court said the precise manner of the event doesn't matter.
Wait, what does that mean? The precise manner.
It means it doesn't matter why the driver lost control, whether it was a seizure or he fell asleep or he was drunk or just a terrible driver who got distracted. The general risk, a car crashing into the work zone, was completely foreseeable. That's the whole reason for the safety rule.
So their conclusion on element one was that the act was not extraordinary.
Correct. Not extraordinary in its general type, even if the specific cause, the seizure, was unusual.
But hold on, a seizure feels different. It's involuntary. It's not like someone texting and driving. Why wouldn't the court see that medical event as being, independent enough?
That's a great question, and it's a tempting argument. But the court's focus is on the defendant's duty, Felix's duty. Their duty was to protect against negligent drivers, period, whatever the cause of that negligence. The driver's specific reason for crashing is relevant to the driver's liability, but it doesn't change Felix's duty to put up a real barrier.
Okay, that clarifies it. The duty is to guard against the general risk of a car crash, not a specific type of car crash.
You've got it.
So then let's move to the second element. Was the intervening act independent of or far removed from Felix's conduct?
Here, the court said not at all. It was the absolute opposite of independent. Felix's failure to put up a real barrier is what directly enabled the very danger that barrier was supposed to prevent. The crash wasn't some unrelated thing that just happened to occur at the same spot. The injury flowed directly from the original negligence, the pitifully weak barricade.
So it wasn't a situation where their negligence just furnished the occasion for an injury?
Exactly. We'll get to a case like that in a minute. But here, the conclusion on element 2 was clear. The act was not independent.
And after analyzing both elements and finding the act was neither extraordinary nor independent, what was the court's final conclusion?
The court upheld the verdict against Felix. They said a jury could absolutely find that the natural, normal, foreseeable result of not protecting a worksite is that a worker gets hit by a car. Therefore, the driver's negligence was not a superseding cause. Felix was still on the hook.
Right. So the big lesson from Derdiarian is if your job is to guard against a specific danger, you don't get a pass just because that danger happens in a wild or unexpected way. To really hammer this home, let's use that contrast case you mentioned, one where the negligence is truly independent. You mentioned the Derdiarian court cited a case called Ventricelli v. Kinney System Rent a Car. Can you give us the facts?
Sure. In Ventricelli, a car rental company negligently gives the plaintiff a car with a broken trunk lid that keeps popping open. So the plaintiff pulls over on the shoulder of a busy road to try and fix the trunk. And while he's standing there fiddling with the latch, a completely different third-party driver negligently swerves off the road and hits him, injuring him badly.
Okay, this feels tricky. The faulty trunk is the reason he was on the side of the road. But why did this court say the rental company was not liable?
It's that distinction we just talked about, creating the risk versus just creating the location.
Go on.
In Ventricelli, the rental company's negligence was providing a defective trunk. What's the foreseeable risk of a bad trunk latch?
Your stuff falls out on the highway. Or maybe you pinch your hand trying to close it.
Exactly. The foreseeable risks are all related to the trunk itself. The defective trunk didn't in any way increase the risk of being hit by a random bad driver. The negligence just furnished the occasion, as the court said. It put him in the wrong place at the wrong time. The injury he actually suffered being hit by a car was totally divorced from, and a different kind of risk than the one created by the faulty trunk.
I see it now. So because the risk that actually happened was independent of the risk the defendant created, the driver's act was superseding.
Precisely. In Derdiarian, the risk was car hits worker. The injury was car hits worker. In Ventricelli, the risk was trunk problem. The injury was hit by unrelated car. Different kinds of risk.
That distinction is incredibly helpful. Okay, let's synthesize all of this. For the listener facing an exam, what's the step-by-step checklist to attack a problem with an intervening act?
Okay, here's a 5-step diagnostic that will walk you through it every time. Step 1. Check for substantial cause. This is just the baseline. Was the defendant's conduct a substantial factor at all? If no, you're done. If yes, move on. Step 2. Identify the intervening act. Just be clear in your own mind. What is the separate third-party action that happened after the defendant's negligence?
Simple enough. Then we get to the two big tests from Derdiarian.
Yep. Step 3 is the foreseeability check. And you ask this specific question. Is the risk of this intervening act the very same risk that made the defendant's conduct negligent in the first place?
Like in Derdiarian, you failed to guard against cars and a car crashed. Foreseeable.
Right. If the answer is yes, it's almost certainly not superseding, and the defendant is still liable.
And what if it's not the same kind of risk?
That takes you to step 4, the independence check. Here you ask, did the initial negligence just furnish the occasion for an unrelated injury, like in Ventricelli? Or did it flow directly from the danger created? If the negligence just put the plaintiff in a particular spot and then something totally unrelated happened, the act is independent. It's superseding.
And then the final step.
Step 5 is to conclude. You just put it all together. If the intervening act was foreseeable, or it flowed from the original risk, it is not superseding. The first defendant is still liable. But if the act was extraordinary A&D independent, then it is superseding, and the defendant is off the hook.
That framework is perfect because it keeps the focus exactly where the courts do, on the scope of the defendant's original duty. The bottom line, the knowledge nugget here, is that the law knows that bad things can happen in sequence. Just because someone else was also negligent doesn't give you a get-out-of-jail-free card, especially if their negligence was the very thing you were supposed to be preventing. So, to leave you with a final thought to chew on, the Derdiarian court specifically said Felix, the contractor, would still be liable even if the driver was found to be reckless, which is a higher degree of fault than just negligent. But what if the intervening act wasn't just negligent or reckless? What if it was an intentional criminal act? What if the driver had aimed his car at the work site on purpose? How does the policy of encouraging safety weigh against the policy of punishing deliberate criminal harm? Something to think about.